Bridget Mackay. I am an attorney in Petaluma, and I work in the area of estate planning, probate, and elder law. And welcome to my video blogs. These are educational, short video blogs regarding different subjects in the area that I practice. And I'm sort of going back to basics right now. We're talking a little bit about wills for the last couple of blogs. And the question I want to answer today is, what happens to my minor children, so children under the age of 18, if I die and I don't have a will? So one of the basic premises here is a will is the vehicle or the document by which you as a parent of a minor can recommend physical guardianship of children. You could also recommend financial, but we're mostly talking about physical today. So I can say in my will that I would like my child to be raised by my sister if I don't survive their minor childhood. If you're married, your spouse can do the same thing. If you're divorced, your ex-spouse, who is the parent of your child, can do the same thing. And hopefully everybody is on the same page. If you're divorced, you are required to name the child's father as the next guardian, physical guardian of your child. That's typically how it's done. You can technically name someone else, but it will be more of a fight for that person to gain control of the child. I'm trying to think of what that big custody case, Anna Nicole Smith and her child. I mean, that was sort of somewhat of an example. Anyway, if you're a married couple, typically you'll name each of your spouses. If you are single, there's no dad in the picture that would be a guardian or mom, then you name someone that you want to take physical care of your child until they reach the age of 18. Now, once you die and this will is brought to court and the guardianship of your child needs to be proved, there will be a court hearing around the guardianship of your child. Since you've named someone in your will, the judge will take that into consideration as the best interest of the child and the parent's wishes. It's strong evidence that whoever you've written down should be the person to care for your child. If you die without a will and you haven't named anyone, then your child will go through a guardianship proceeding in court where they will determine who is the most appropriate person to place your child with and will reside there and is in their best interest to care for them. That's a lengthy process depending on the complications of the case. So by all means, if you are a parent of a minor child, you should in the very least have a will in which you name who will physically take care of your child, because you don't want the situation in which you have not said anything and your child needs to suffer through a guardianship proceeding.